say, this is a conversation about a topic that hopefully of great interest. This is AI, artificial intelligence. I think it is of particular interest, and I'm very pleased to welcome two, I think, great guests. We did a run through this last week. I thought it was excellent. Andy Yeoman is the CEO of Concirrus, who are a fintech, I think it would be fair to describe you as, Andy, which use AI, and we'll talk in a moment about what Concirrus does with AI and how it uses it. And Robert Sackin, who is a patent attorney with the firm of Reddie Grose, and who is an expert on filing patents relating to AI inventions. So I think we'll start with a poll, just partly to get a feel for who the audience is, and also as a bit of an icebreaker. So could I ask Lizzie to put up the first poll? So, audience, do you regularly use AI or technologies enabled by AI? That's a yes or no answer. So can we see what the answer is? Okay, so that looks like that's been sitting around a sort of 60-40 split. So so that's interesting, and good to know that the majority are using AI or technologies enabled by AI. So that takes us on, I guess, to the first question, which is, Andy, what do we mean by AI? What is AI? And I guess people often associate machine learning with AI. What's machine learning?
Yeah, so from our perspective, so we use the phrases artificial intelligence and machine learning interchangeably. That tends to be, if we're raising money, we'll tell people how much AI we have. If we're trying to explain what it does, we actually talk about machine learning because people understand that. So those two things, a phrase I do think are certainly interchangeable. So we define this as the ability to understand and process massive amounts of data in a far shorter period than could be done by an individual. So whether that be understanding recommendations on Amazon as to people that buy X also buy Y, or whether that's Google Maps, or in the case of our application, how accidents happen in insurance. So again, ability to sort of crunch through massive amounts of data and draw conclusions from that data in a real-time and continuous basis.
Sure. So actually, one of the almost universal requirements, but one of the almost universal features of applications of AI is that presence of a large amount of data, which can be analysed in a way that couldn't be analysed simply by human beings.
Absolutely, yes, yeah. So it's I think computing in many respects is the manifestation of human experience, but we talked about this earlier. We've taken something like Google Maps, which is about routing. Google Maps gives you the access to the experience of everybody that's used it effectively, and that's not something that you would be able to manifest without that. You couldn't call around everybody that's travelled, understand where they're going. You'd like to be at this junction at 4 o'clock. If the traffic slows down, could you let me know? That's just a capability that would be impossible to replicate without communications, and more importantly the algorithms that run through and learn those patterns and behaviors. Okay,
interesting. So you touched very briefly there in that answer about on what Concirrus does. Do you want to tell us a little bit more about the Concirrus?
So we're a fintech, or more specifically within that category, an insurtech. So we use artificial intelligence and machine learning to predict claims in commercial insurance. And specifically, we focused on the areas we focused on is like marine insurance, and so the movement of goods and vessels around the world. So the movement of goods, I think 85% of all goods that move these days travel by sea. It's a massive market, and the insurance of the assets that move those, so the vessels themselves, that marine insurance is something like a $30 billion plus industry. It's the most traditional industry that's existed in the insurance market. It was the founding of Lloyd's sort of 200-300 years ago, when people were in the Lloyd's coffee shop, which is now Sainsbury's, if anyone wants to go and find it out. But it was founded on the back of the marine industry, and that market has operated the same way for pretty much 200 or 300 years. So they're very paper-based, they're very experience-based, relationship-based. I say it's operated that same way. So what we've done is taken a different approach. Is we have curated a data set which has got several trillion rows of data, everything that you can find out about the marine insurance industry, and we've used the aggregate experience to predict claims, and we can outperform the individuals in the ability to understand that data. Of course, once you can predict claims, you can start to understand the risk that's involved in a given insurance policy. You can price that appropriately, and then you can allow the underwriters to do a quicker job and a more effective job. So much like Google Maps, if you turn left, it's 10 minutes quicker. If you turn right, it's 1 mile shorter. We do the same thing. If you write this business at this price, this is going to be the impact of your aggregate loss ratios. So we do many of those things, and then some.
Okay. And presumably, that pricing piece is something that's historically been done by insurance experts, by individuals with a great wealth of experience, based on their understanding of the risk.
Yep.
And how have you found the ability to persuade those people that actually what they do can be automated and be better done by?
Well, we've had to be very careful. So everybody, when you approach these situations, every underwriter has a certain bias in the business that they would write, and that bias might come from their training, where they were told that ships built in Germany have had quality issues, so they stay away from all ships built in Germany. Or other biases, they may have had a certain experience with certain vessels and vessel classes. The most extreme one I've heard actually is that someone said they don't write Turkish fleets, and the reason they don't write Turkish fleets there, and I won't attribute it to any individual, but he said, well, I've been on holiday to Turkey 3 times, never had a good meal. Yeah. And that's why he doesn't write Turkish fleets. So people have got a bias in there. The reality is, the human condition is one. We're deletion creatures. There's too much information in the world, so we have to choose what we pay attention to and what we ignore. And the challenge with what we ignore is that there's a lot of distinction to be gained from the knowledge that we ignore. So we walked into the insurance market with a presentation which we called, imaginatively titled, "The End of Insurance." It didn't go down as well as it could have done. We then walked back in with one called robo-underwriting, which again didn't go down as well as it could have done. So until we realised that actually what we needed to sell was a solution that could augment the solution, augment their experience, not until we did that did we really get to a position where we got some traction. And we talk a lot about, we use Google Maps as a metaphor or an analog to our business, and that does seem to work well for us. So with Google Maps, it's down to you. It gives you, turn left or turn right, and this is the implication, but it allows you to choose yourself which way you want to go. So we don't automate that decision. We just augment the decision with additional data. And we found that that's been the most useful way to do it.
Yeah, that's really interesting. I wonder, you've mentioned Google Maps a few times there. Lizzie, can we have another look at those poll results? So I wonder if the 38% who said they don't regularly use AI would now want to reconsider if on the basis that they do use Google Maps or similar. Or actually, the other example I know that we discussed last week was people that shop with Amazon that buy something that's been recommended by Amazon, which is another very common and very clear application of AI. Thanks, Lizzie. So obviously, quite a lot's been invested in developing your product, and you've been reasonably successful in getting it out there. And can I ask, have you thought about intellectual property protection for your technology, and if so, what have you done?
Yeah, so there's several things. So one of the things that as a technology company do, we're always trying to protect our sort of competitive position in the market. So we protect it by many means, and we discuss this. We do the things that I think everybody probably does, is that we've looked at, we implement confidentiality agreements in our employment contracts, we implement NDAs, etc., to keep everything confidential. we copyright our logos and our names, and we make sure we fill out those registrations. When it comes to the core technologies, however, it becomes a little more confusing. So we're aware. If you look at our technology, we have some algorithms and a whole bunch of algorithms and technology in there. We have some know-how in the organisation of how that's put together. We have our code base. And somewhere on there, we must have some intellectual property that we can go to the patent office and protect, you'd think. And we've been pondering that for a while. And as we discussed last week, our pondering is probably made up of balanced by both opportunity and fear. So, wouldn't it be great if we could get a patent for our technology that nobody else could do what we do, and then we'd get an effective monopoly? That would be fantastic. Our fear is probably twofold, which is how much am I going to have to pay in lawyers' fees to get that done? We discussed your competitive rates last week. So, and more importantly, how much do I need to disclose in order to actually, for an application to be successful? And then there's the time factor, not the time it takes for us to put the effort involved, but actually, if I look at the evolution of our technology, and then look at how quickly the application process takes, by the time I got a patent, it would probably be irrelevant to what we're then doing. So, we've been considering that for a while. It may argue that actually we may have let a few opportunities escape us through our pondering. Prepared to take that one on the chin, but I think that we absolutely see that there's value in it, especially as we eye up the US market. We absolutely see that there should be an opportunity, intuitively there should be an opportunity for us to patent some technology and give ourselves either an advantage or ability to protect ourselves in the event that someone else comes at us. But it is very much a sort of a confusing and unknown market, especially when you get to the AI. Trying to explain what you do is tricky enough to an underwriter to explain why a price is a price. Trying to actually set out how we do it and make that consumable by someone reading the patent application, and yet not give away our core intellectual property. That for us is a bit of a balance that we've not quite figured out how to make.
Absolutely. Well, let's hope that in the next 20 minutes or so we can answer some of those questions. But before we do so, I think it will be interesting to get a feel for how many of the people in the audience have experience of the IP system around AI. So, Lizzie, can we get our second poll question up? So, two questions here, actually. First is, have you had experience of trying to protect AI-enabled technologies? And those that have, how was that experience? I'm giving you great, okay, or difficult. Okay. Well, that's really interesting. The first thing I'd say is that a good proportion of the audience are answering, yes, possibly more than yes. For you, Robert, and for me, those are slightly reassuring numbers. But having heard what Andy had to say, how can businesses that are based on AI-enabled technologies like Concirrus, how can they protect what they've developed, their technology?
Well, from the patent side, it's not necessarily straightforward. So only certain subject matter can be patented, and there are some restrictions. It, of course, varies slightly from country to country. Andy mentioned the US being an interesting market for him, as it is for many of my clients I work with. The UK and Europe as well, also big markets. But roughly speaking, in most countries, requirements are broadly the same, and that is your AI invention to be patentable needs to provide a technical solution to a technical problem, and in that can be broken down sort of to the AI sphere into sort of two ways of looking at it. You either use your AI to provide an advantage in the real world. So you use your AI to, say, make a better washing machine or a better car, something real. That's an avenue that's probably not available to Concirrus. They're in the insurance market, probably considered a business process, possibly a medical act, possibly mathematical process, all things that aren't patentable. The second area where they may be able to get value protection is more in the actual implementation of the AI. So it's really that you're making the computer running the AI work better. So you're taking into account the processing limitations or memory limitations of the computer, and you're thinking about those when you're implementing your AI. And so that tends to be, if a business like Concirrus have got huge amounts of data, you're thinking about the memory limitation, storage capacity of your computer, and how you're having to break down that big data into a smaller chunk to work efficiently on the computer capacity you have available. That's the kind of thing that might be patentable. It's slightly, the US is a slightly different market. That's the sort of position in Europe and the UK. The US position is roughly the same, but the difference is that the UK and Europe position is pretty much settled, probably, hasn't really changed much over many, many years. The US position, historically, until about 5 years ago, was very friendly to these kind of inventions. And any AI could be protected as long as it was on a computer, which of course always would be. And that shifted to more the European style, but it's shifting back at the moment. And over the next, say, 5 years, it may go back to being much more friendly again. And over the time it takes to get a pattern that Andy was saying, it can take, usually does take several years. You may have better luck in the US than you would do in Europe and much of the rest of the world.
Sure. And what other forms of protection are available? I mean, AI, it's in the end, we're talking about computer software, and computer software is a copyright work. But I think Andy hinted at this earlier. Very frequently, the way you actually do it is something that is confidential and can be maintained as confidential information.
I mean, that's always the balance between the choice of you can't have a patent and keep it confidential. So it's a choice you need to make about what you want most, and that's quite an interesting area with AI, when you can't readily reverse engineer the AI, and often it's, for example, implemented in the cloud. Often you're not selling the AI itself, but you're just giving the answer to your customers. They don't really need to know or want to know how it works. They just know the answer.
And Andy, that's the case with Concirrus. Effectively, a customer logs onto the Concirrus website and asks for a price, and your system gives it to them. They never get the software. You don't send out a disk or give them a download of any software.
What's a disk? No, ours is a web-based platform. We do provide explainability, though. I mean, one of the things that we found, because we sell into what's a regulated market, we found that you couldn't get to a situation at the end of the year if the regulator said, well, why did you write that business at that price? And the answer was, well, the computer told me to. Yeah, that's not gonna last. So we invested a lot of money in explainability. I think breaking open the black box model and actually providing explainability of how that price was derived. But yes, you're right. It's all in the cloud, all on demand.
Yeah, which is very different from somebody that sells a pharmaceutical. If you have a patent for a new pharmaceutical and you sell that pharmaceutical, someone can buy the pharmaceutical and analyze what's in the pill. So that's not the case. And it's interesting, in the chemical industry, there's a balance between. So Robert, you sort of hinted at it, but there is this requirement in a patent to have an enabling disclosure. What's the requirement there?
Yeah, that's right. So a patent it's a deal between both the government, the country, and an inventor. And to have your 20-year monopoly that a patent gives you, you have to give the world the information to make the invention. And so for a valid patent, your patent has to describe enough information to let this fictional character called the skilled person, who's, if you like, a technician, no imagination, he or she or a team must then be able to go away and make the invention, give the information in the patent application. Actually, in practice, it's a fairly low test, and you don't need to include massive information. Although the test is the same across technology areas, my colleagues who do sort of life sciences patents, for example, have a much harder time than we do doing computer Inventions about the level of detail needs to be included, but some level of information needs to be included. And the patent office won't test it, so it needn't be completely.
I was going to ask if the guys in life sciences have a harder time with enabling disclosure, because actually there's more litigation, and whether it's an enabling disclosure gets tested more frequently.
Absolutely.
Yeah. So you get a balance there, don't you, between the desirability of your 20-year monopoly, but having to give up an enabling disclosure in order to get it, against maintaining this confidential and keeping it ahead. And I guess one of the issues there is the sort of technology life. How long, on average, does it take to get a patent from the date you file?
It varies, depends on jurisdiction. Typically 3 to 5 years be normal. You can fast track things, again, depending on the patent office. A year would be fast. You can do it quicker, but a year is about as fast as it gets. And a slow patent office, or watch India, they're not pouring it out at 10 years plus. Sort of time scale. So obviously for a business like Concirrus that's probably continuously innovating, and I suspect will have moved on from every year you're doing something different. Maybe those time scales are no good. But the important point, and of course you can only enforce your patent once it's been granted. But actually the pending application, it can still be a very powerful tool even without it going to grant. For various reasons. I mean, it's backers would like to know you've got applications filed, even if they're not yet granted. It's better than nothing. I know you've got the possibility of getting some protection in some time scale. It's a warning to third parties that you may have a patent, even if you've not actually got it granted yet, and that may keep people away from your space. They're probably the main reasons why you don't think you need a granted patent. Having something there is a really good thing to have.
Yeah. And there are other functions that patent portfolios can perform very often. Well, certainly there are industries where they're seen as defensive tools. So in industries where competitors may have a lot of patents, then having some patents in case the competitors threaten infringement actions against you, so you've got something they may be infringing.
Absolutely.
Is often seen as quite valuable. But actually, we're beginning to see that in some AI technologies. We're beginning to see significant patent portfolios, even bearing in mind some of the issues you've already outlined. And so as a defensive position, the other thing that a patent application can do is prevent a competitor getting a patent for something you've been doing. If you filed something and put it out there, then it's prioritized against their application. So lots of things to consider. And then we haven't touched upon branding. Andy, you're sitting in front of a very attractive Concirrus logo.
As I'm reminded by my marketing team, a very out-of-date Concirrus logo.
and you mentioned earlier that you looked at trademarking and taking steps there. And actually, it's always important to remember in fast-moving industries in particular that the value of a brand is important. Have you found that? I don't know. What's your competitive position like? Are there competitors?
Yeah, we have competitors. Yeah, sometimes those competitors, we have direct competitors. We compete against inertia. The fact that, well, why do anything? This year has been actually quite useful from that perspective. I think there's been a good deal of momentum around why you should adopt digital technologies. But actually, I think that having a strong brand is really important because as a tech company, unless you're always going to do one thing, the ability for you to sort of stretch your brand and reinforce it is quite good. And we recently announced an extension to our product line, and it puts us in competition with a couple of other people. But interestingly, we believe that actually, because we've launched it, our target customers will favour us because of the fact that we've established a reputation for having sort of high quality solutions in the market. So I think that it's really important to build a sort of a brand identity and to protect all the attributes around that. Yeah, when it comes to actually selling customers, raising money, and actually hiring people, you know, the brand does a lot for you.
Yeah, and it's worth noting that there are some very large technology companies who value their trademarks higher than their copyright or their patents. So I think that may be true of both Microsoft and Apple, which are obviously incredibly significant brands. Just talking then about your competition, do you, I mean, presumably for the same reason that people can't see exactly what technology you're using because it's available through a server and not through the cloud, you don't know exactly how your competition are providing their results.
No, we don't, and I think that's sort of just symptomatic of the industry as a whole, isn't it? You know, you kind of have to judge by results, which I suppose in some respects is quite interesting. I'm trying to think that it's an interesting question. We didn't practice one, you know, didn't talk about this last week, but a bit like if I go back to, retreat back to my familiar metaphor of Google Maps, you know, if you kept ending up in rivers or stuck under bridges or whatever, you'd soon stop using that technology. Yeah, and you know, we live in a very intolerant society. So you know, if the stuff that the algorithm recommends isn't what you want to have, or you don't want to buy, or it takes you into a river or whichever, you very quickly lose it. You don't persist with that technology, and we find that with our customers as well. Is that if we're not adding that value, if they can't see that immediate value add, then we are a sort of competitive threat. So it's a challenging market. I know I sort of drifted slightly off of what you were saying from a competitive perspective, but you know, we found that we have to have an obsessive focus on your customers and adding value in there. And if you, to the point that you made earlier about it, you know, we talk about explainability. It's great having a technology, but if people don't understand it, and they can't explain it, then again they won't use it. So it's a very fine balance that you make.
Sure, and it's interesting that point I think illustrates two things, doesn't it? It is, firstly, again, it goes to the strength of the brand. You know, you're reliable. You provide good results. Google Maps is reliable. It tends to get you there without taking you into rivers or hitting bridges. So there's a strength in the brand. But actually also, if you had a patent and the competition was infringing that patent, if they were using AI in exactly the same way to produce the same results, you'd find it very difficult to prove that, wouldn't you? Because
we would, yeah, we would. You rely on sort of back channels of information in the industry, which often wouldn't be enough to. It would be enough to sort of raise your suspicions and perhaps your blood pressure, but probably not enough to sort of launch any form of legal action.
Yeah. Okay, that's interesting. So, you know, would the system be better if, for instance, patents were available quicker? Robert, do you think that's?
I think if you want them quicker, the acceleration schemes available, I mean, they can be granted fairly quickly. I mean, so a year seems to be okay as a quick thing. I think that's probably okay. I don't think that's particularly an issue. I think for me the issue is more the uncertainty about validity, about the issues of patentability is more in this space.
Yeah, and I think that the point we were talking about earlier about disclosure, disclosure to get it. It's great if you get it, but if you don't, then all you've done is tell everybody what you do.
I mean, there are tricks you can play to a certain extent. So a patent application publishes 18 months from filing for its filing date, and so you can be, if you accelerate prosecution, you can be in a position having a good idea that you'll get a granted patent or not before it publishes. It's like nuance. If you have, I've done this rarely, and it's a bit of a quirk of my practice, but the US is one place where you just file a US patent application. You can avoid publication of the application and just wait until it's otherwise it'll have for grant, and we'll just publish a grant. You just go US only. So you've got some control of no, if you're going to get a patent, you know, it'll publish, and if not, you can keep it secret. Because once you file an application, the content it's still secret until there's publication 18 months away. Yeah. There are some minor bibliographic details, the applicant name, the filing date, and these very minor things, I think substantive, that become public domain. But there are tricks you can play.
Yeah. And but in the end, nothing that gets around the policing question. How do you identify whether someone is infringing your patent if it's a service that's delivered to the house?
Maybe the market needs a bit of AI that reads patent applications and understands and flags which companies might be infringing them. Then you need to file a patent for that as well, and it's going to get we're going to get into a loop very quickly.
And then, Robert, one of the other things that actually intellectual property can be used for is finding out what the intellectual property system can be used for. I should properly say is what are the competition doing? So do you want to tell us a little bit about what patent landscaping is and how businesses may benefit from that?
Yes, I mean, I think sort of patent landscaping kind of comes in, as I look at it, in two sort of flavours, depending on where the company is in their product development life cycle. So you might landscape, that's to say, look at the patent landscape, the world, what other patents people have got very early on. Perhaps you're going to a new technology area that you haven't worked in before, a new business area, and you really don't know what your competitors are up to. You might do kind of a blue sky search. And you might get, it's a fairly vague question actually, you know, if I'm going into the industry, you might think about, I want to go into the insurance space. I'm moving away from shipping insurance, I'm going to go into car insurance, for example. Quite a different change. You know about insurance, but you don't know about the details of the car insurance market and what's going on. Then you might do this sort of fairly broad, and it's a slightly vague search because the question is quite vague. But it might flag up the big filers in that space, might be some surprises, some people who you weren't expecting to be there. And it might give you just an indication of particular niche areas where there are a lot of patents, a danger area, a high risk area, or lower levels of filing. And that might help you shape more detail where you want to go. And that's the kind of thing I've done when I've had top technology consultancy clients, where they're trying to sort of come up with some broad ideas, and they want to get some idea of what landscape's like. And the other flavour is when you've developed a product, you perhaps at the prototype stage, and you kind of know you've got a product that really is perhaps close to market or getting nearly there, have some ideas, and you want to know have a good level of the risk of patent infringement. That's a much more specific question. You need to get a much more specific question back about whether the real risks about aspects of your product, whether or not they infringe or not. And again, it might flag up particular areas where competitors got a lot of patents or few patents. If you've got a product, it probably doesn't work so much in this space. You've probably just got an AI thing, but in other areas where you've got a product with a lot of components, perhaps you've got a motor and a battery and some mechanical gearbox between them, for example. Each of these have different patents around. It'll flag up where the risk areas are, and so it's all helpful stuff, and gives you a level of risk. You can't tell. We're never going to say to you, you're not going to infringe someone's patent. We never will have enough information. But all we're giving you is a good idea of the levels of risk, and some of that will become more useful to you because you might know that particular person, entity with lots of patents is quite litigious, or you're quite friendly with them. You don't know, and it's that sort of interaction that we get from their need from it.
Yeah, and I've seen clients done landscape exercises to identify areas where the competition aren't active.
Yeah.
And see perhaps opportunities to focus their R&D resources.
They're quite surprising. Some very strange players who've got huge numbers of patents in a space you never expected, and vice versa. It can be really quite surprising, the outcomes. It's what they're interesting to do. Yeah,
that's interesting. So I mean, I guess we we're in summary, it seems to me that we've got a patent system which has one really positive strength, which is that it gives you a 20-year monopoly. A 20-year monopoly is a very valuable thing, but it appears to have a number of drawbacks in AI-enabled inventions. One is the period of time it takes to get a patent to grant, which can be, in some cases, I guess, is going to be the length of, is going to be as long or comparable to the lifespan of the technology.
It's been known to happen, yeah.
There's the fact that you've got to have an enabling disclosure in there, and actually we're talking about a technology that you don't have to disclose by, when you sell your product, you're not actually selling the software, you're not selling the AI that lies behind it, you're selling the results that come out of a black box, and customers can't see into the black box, so nor can competitors. And some difficulties in enforcing it. Even if you've got your patent, it's going to be difficult to prove what can be done. And we briefly touched upon copyright. Obviously, we said there's software here. Software is a copyright work, but if it's difficult to prove that a competitor's software is working in the same way, proving that they've copied your software is can be very difficult. In fact, it's very unlikely they will have done unless it's industrial espionage, because they won't have a copy of your software. It's not something that's been put on one of those quaint old things called a disk, and it's not something that's been downloaded from the cloud. So I guess going back to the question then is the system that we've currently got fit for purpose? And I think, Lizzie, if we could put up the final poll we had here. So there we go. Do current IP laws provide adequate protection for AI-enabled technologies? We've given you a multiple choice here. Yes, fine as it stands. No, patent law needs to be changed to protect inventions that are currently excluded. So do we get rid of the software and business method exclusions? No, patent law's fine, but we need a new right with a shorter lifespan to protect novel functionality in computing and AI. No, the whole system needs to be reviewed and brought into line with the 21st century world. No, patents are wrong and this IP right should be removed from the statute book. We did ponder whether to put the last question in because we thought it was possible that nobody knew. And there are quite a lot of people with that view, but that those may not be the audience members. But what do we think? What do people think? Okay, so that's actually really interesting, and possibly not the results I was expecting.
I wasn't expecting that. Yeah.
So we do have no one that thinks that patents are wrong, which is, to me, a relief, and to you, a relief, I'm sure, Robert.
Absolutely.
Actually, 25% think the whole system needs to be reviewed, and that's interesting, and it is a view that's not uncommon. I think that intellectual property law is a law that's been developed over centuries, and the way the 21st century world works, it doesn't really quite work. But the majority view seems to be, well, the largest number of people have gone for the third option, which is that we need to be thinking about a new right that protects functionality, novel functionality in computing and AI. And I must admit that's something I find myself. I have split views myself on that, but Robert, what do you think about those results?
Yeah, I'm surprised, and I'm not really quite sure what this desired right, what kind of form it might take. So many countries have a thing called a utility model. Germany is the classic one, which is a so-called petty patent, which is a short-term patent around 10 years lifetime, and often they're granted without examination, so they're just granted whatever you file, and they're only examined if you try and enforce them. And maybe that is something we should consider as a country. Those sort of rights are available, and sometimes they are quite quirky on different countries that have them. I mean, they're being filed in colossal quantities in China, so they're staggering quantities in China at the moment. And Germany's always been a big market for this kind of thing. But they do have some limitations, and still often the same patentability exclusions apply as do for regular patents. And perhaps, I think my vision of a 21st century patent world is the bit of the statute to do with patents that has to do with subject matter simply deleted. And so patents are only assessed based on whether they're novel, i.e. not been done before, inventive, i.e. how smart they are. That's the kind of vision I would have. It's a simple fix. I think the system's wrong where, you know, a business that's innovating like Andy's has less available than a sort of more traditional business that makes mechanical widgets.
Andy, as the customer of the system,
yeah,
what do you have a view, or are you waiting to have more experience of its form of view? And what do you think about those results?
Well, so I think I reviewed I looked at the results through a slightly different lens, in that I just went, well, only 8% of the people like it.
Yeah.
So, so whatever the, whatever the change might be, and we kind of gave people 4 answers. Yeah, we know that 92% of people want change. There's a bit of introspection required, I think, by the powers that be on that one.
Yeah.
I think that there definitely needs to be a process which is shorter and easier to get the patent. But I think the quid pro quo is that the 20 years is probably too long in some respects. So if there's a bit of a give, there's got to be a bit of a take. And I think that understanding the value of patents and the protection that you're getting is useful. And, I go back to the pharmaceuticals. When you're spending billions of dollars to develop a drug, then the return on that is 10 years. Then I think a 10, 20-year patent seems reasonable. As a tech company, we certainly don't spend billions of dollars. We spend millions. So I think that there's room for some manoeuvre in there.
Okay. It's interesting that actually your take is very timely, because, and we didn't know this was going to happen when we put this in the diary, but a couple of days ago, the UK Intellectual Property Office has actually launched a consultation on AI and intellectual property, seeking views of anybody that wants to put them in, but I think particularly of industry. We're looking at that, and I think we're probably going to give an opportunity to maybe arrange some round tables with clients who want to express a view. So if anybody in the audience actually has a view on AI and would like to discuss that and feed back into a response to that UK IPO consultation, details of that will be circulated in some of the follow-up to this session. But it's clear that the IPO recognises that they at least need to take views of their users and people affected by intellectual property, and work out whether the system does work in the modern world and for AI. So it will be interesting to see how that consultation proceeds. I think now what we'll do, given that it's nearly 10:02, we should probably throw the floor open to some questions. So Isabel, do we have a question?
Yeah, there's one here asking about the access to data issue. So if you have a major data holder or collector, where we speaking about Amazon before and Google Maps and things, does that mean that they become overwhelmingly dominant in the AI field because that data underlies the machine learning that has to be carried out to innovate?
That's really interesting. And Andy, how ready is access to data in your industry?
So it varies. I mean, data, what's that phrase? Data is the new oil. I'm not quite sure I buy into that wholeheartedly. I don't tend to buy much oil, but I do buy petrol, which is a distilled product. So there's no doubt that these AI-based engines, such as the one we do, absolutely feed off of raw data. There's no doubt about that. And we need to keep feeding that engine with new data. But the data that we use primarily is broadly available. We've got about 30 data sets, all of which any party could go license, and they could they could go and compete with us if they so wish. So from that perspective, I think we're a bit of a level playing field. The question about Amazon and Google, this is a personal opinion as opposed to a company opinion, is that I think that there's a change coming with the notion of, I think they're called personal data containers, which actually is that I want my data to be to be mine. We are. I think in terms of our ability to give away data, we are going to go down in history as the generation that was careless with our data. And so the quid pro quo is that someone said, well, why did you allow this company to know everything about you? Well, it's because they gave me a sticky smiley face that I could send to people. It was quite funny. And people are going to look at you and they go, why on earth would you have done that? So I think that as much as data is being generated, I think that the data privacy laws are increasing, which is going to make it sort of, in some cases, certainly around personal data, more difficult to get hold of some of that data, and certainly more difficult to keep it on a long-term basis.
Yeah. And I think it's undoubtedly true that there are going to be companies which, by virtue of the fact that they're very large companies and an enormous amount of business, obtain very large amounts of data, and Google and Amazon are right at the head of that. I don't know what the answer to is in terms of enabling competition, but I suspect the competition law may at some point have a role to play there, and we'll see how that plays out. I think it's going to be one of the next big questions. And it's actually also quite an apposite question, because it gives me an opportunity to plug the next of these sessions, which is going to be on the 5th of November. And we're looking at big data and rights in big data in that session. So anyone interested in that question should look for notification of that session when it comes out. As I say, same time on Thursday, the 5th of November. Isabel, do we have another question?
Yeah, the next question is about value. Is the value of the IP and the licenses you have based on it likely to be higher if it's patented or kept as a trade secret? Maybe Robert, we might want to comment on that.
The answer is it depends. I think it's the balance depends on the product. As we discussed, there is some value in keeping something secret, and there is some value in having that IP protected. It depends on the details. And I mean, I know about valuing patents, and the answer is it's very, very, very hard to value them anyway. So you probably never really know. But you have to make a judgment as a business what you think it's worth to you. Is perhaps the way of looking at it.
Question. I took part in another seminar on Monday, which was organised by Oxford, who are an economics-driven valuer of intellectual property. And on the panel with me was an investor and a tech entrepreneur. And actually, I think perhaps to the disappointment of the host, I think we all agree that actually the value is really in the technology, and that you should never lose sight of the fact that what intellectual property does is protect the technology. And the correct answer to which is the most valuable is which gives you the best protection. And the answer is, as I think Robert said, it depends. You've got to look at the best way to defend and protect your your technology. And in some cases, that's going to be trade secrets. In some cases, that will be a patent. In some cases, it may be a combination or something else. But actually, the important thing is that intellectual property is something that can protect something that already has value. If the technology has no value, then the intellectual property won't either.
Sometimes.
If you want to answer all these questions, what does the AI think? That's what it'll tell us.
Yeah, sometimes investors quite like the sound of a patent portfolio, don't they? I don't know if you've got any experience of that, Andy, but it can be music to the ears of investors.
Yeah, there's some people drill on the patent, but it's more what have you done with it rather than what do you own, So we as a company, despite all my conversations, we just happen to own a patent for the transmission of radio frequency through a steel container. Yeah, we just happen to own it. So if I go out and say, yeah, we've got a patent, they go, great, what is it? Nothing to do with what we do. Yeah. So.
And I think it's worth saying that investors are a little bit more savvy than they used to be. it's not that long ago that I was involved in a transaction where a drug discovery company was raising. It was an in silico drug discovery company, and they were raising quite a significant sum of money. And the investors, we in the due diligence process, we disclosed that actually they had a family of patents that they no longer used because they didn't work. The technology protected by those patents didn't work, and they had taken the decision to let those patents lapse. And the investors went into a flat spin and put a stop on the process because they couldn't understand why anyone would let a patent lapse. And we had to take them through it very slowly. And in the end, to get the process back on, we agreed to pay renewal fees on patents that protected the technology that didn't work. I don't think that would happen now. And that's probably only 5 or 6 years ago. So investors are getting more savvy as to recognizing what's there, but it can still be reassuring to them to see a patent portfolio.
There's another interesting question here about training data. So if an AI model is trained using a customer's data and your intellectual property, who owns the IP to the trained model? So you've got the customer data and the algorithm in another party's hands. Where does the ownership end up there?
Robert, do you want to tell us who would own a patent on that?
Well, I think the patent would be in the AI model, not in the data, probably. So I think I'm probably okay that it's the person with the model, probably. There's an element depending on the details, but I think that'd be my answer.
And the same is true. You know, if it was valuable confidential information there, the valuable confidential information will relate to the model rather than the data on which it's being based or on which it's trained.
Yeah, a slightly different answer. My view is it depends what's in the contract.
Yeah, that's
which is actually that's the correct lawyer's answer.
Yeah. So if you are an owner of data, important data like that, then it's really key to make sure you protect it up front before you let the project start.
Google only own our data because we've signed a contract and agreed that are using their site that they can own our data. So we've gifted it to them.
And increasingly we're spending time drawing up agreements between corporates who are working together on developing solutions to problems where they're both, to use a horrible modern phrase, stakeholders. And actually one of the most difficult parts of negotiating those agreements can be who owns what coming out of it. And it's important, and actually again we'll touch on this on the 5th of November. Data has enormous value, and enormous data has enormous value.
Yeah, and the contracts do as well. I mean, we all use products from Apple and Microsoft and Google, and we all scroll down and hit accept. Yeah. I will not be surprised if one day there's a knock on my door and the man from Apple says, "We own your house." Yeah. And he says, well, how did that happen? Because you clicked and agreed to that in the last update of the software. Yeah. You know, because I just scroll down, I click accept. Whatever it takes for me to get that smiley face icon, I'm going to do it.
Mark, have we got time for one more? There's another.
We've got time for one more. I was actually going to say that I only know one person that's ever read all of those terms and conditions, and I know Alistair's part of the audience today. And even then, he only did it. I think he was going on TV to talk about it. But I think those terms and conditions are written to be unreadable. But anyway, yes, one more question.
They're written to protect the interests of those providers.
Yeah.
Yeah, this is a really interesting point. It's about, we've been talking about some of the big players, but from the perspective of a smaller player, having a patent may be not much use to you if you can't afford to litigate over it. And that kind of sets the playing field up against the smaller player in some ways. Mark, what do you think about that as a litigator?
Well, I think that's not a question that's unique to AI. I think one of the really big problems that the intellectual property system faces is cost of access. And cost of access isn't just the cost of getting the protection in the first place, which actually isn't as brutal as sometimes the perception is, at least not in the early stages. But the cost of enforcement can be eye-watering. And absolutely that gives an advantage to the big players. I mean, there are things that can be done to mitigate. There are an increasing number of insurance policies available. for people where you can insure your intellectual property so that you can protect it. And I think, one of the pieces of advice I will always give to an early stage business, you should look at insurance. You should look at what you can get to insure, both against people infringing your IP, but also against big players coming after you. So defensive IP insurance. So I think that's one mitigation. We've got an improvement in the court systems in the UK. Certainly the courts are trying to cut down timescales, and time costs money, but they're also trying to encourage cheaper litigation. So we've got the Intellectual Property Enterprise Court for lower value claims. But I'd have to say that it still remains the case that IP litigation is expensive, and it is something that businesses need to think about in terms of their strategy, what they can do about enforcement, and ways of preparing themselves to put themselves. There are some great examples of smaller businesses that have been successful against larger businesses, and no matter how aggressive larger businesses are, most of them don't want to get involved in litigation they're going to lose, and certainly don't want to get involved in litigation where there is reputational damage that might flow out of it because of the way they conduct themselves. So it's an issue. It's probably an issue needs looking at, and it may be an issue that should be looked at by the IPO in the consultation. But I don't think that it's a concern that should stop people looking into getting proper IP protection. I don't know, Andy, as that smaller business, have you got a view on?
Yeah, we've been on neither end of a lawsuit. I have experience from a previous company. We were a large organisation, and we owned hundreds of patents, but we used them to defend ourselves against other people suing us rather than going out aggressively and enforcing those. Maybe a couple of exceptions of where some of our technology got replicated in China, but that's one side. We did relatively little on it.
Good.
This is certainly my experience. I mean, as a firm, we act for some small startup type clients up to some very, very largest companies in the world. And our experiences aren't that the large ones are trying to trample on the small ones and the small ones are being trampled on. The general feeling from 20 years experience I've got is that it does seem to work. The pattern marks your space, and people generally respect it.
Yeah. Good. Okay. Thank you. I'm conscious it's just gone 5 o'clock, and we said we'd finish at 5 o'clock, so I'm going to wrap the proceedings up there. Thank you very much to Andy and Robert. It's been a really interesting conversation.
Thank you.
And thank you to all of our attendees. I hope you've been as interested in listening to what we've had to say as it's been for us to prepare for this. Just a reminder then, the next one of the Talking IP sessions, again, is on data and rights in data. That's on the 5th of November. And just to say, there'll be a couple of articles following up on this session, which will be on our website in the near future, and we'll be sending those round by email notification to you so that you can see what we've had to say. We'd be really interested to hear people's feedback on the session and what else you might like to hear talked about in the Talking IP session going forward. So if you've got any views, anything you want to say, or anything you'd like to hear more about, then please do let us know. Once again, thank you, Andrew. Thank you, Robert. And thank you, everybody, for listening.